House Bill 2241 is a bill that deals with out-of-pocket loss. It is a bill that deals with sections 407 of the code. It deals with how we have class actions are formed, are put together, how claims are assembled in those class actions, and it deals with the criteria under which those class actions can be brought together. It is not a dramatic change to the code. It is a clarification of case law. I would suggest that we recess for 15 minutes and reassemble on the side gallery of the House. I would call my first two witnesses. Unfortunately, they are voting in budget, so I'm going to have them present, and I'm going to have to go down and vote in budget.
Mr. Chairman, Michael Grote appearing on behalf of the Missouri Justice Alliance. What I would like to do, if it would be okay with the committee, is simply introduce the two individuals that have come in to testify today, as they can answer the questions to these and present on this bill much better than I. I have joining us today on behalf of the Alliance, Bruce Ryder with the law firm of Thompson & Coburn, as well as Andy Carpenter with Shook, Hardy & Bacon. And they are here to testify on this bill, and I would like to go on record from the Missouri Justice Alliance, which is a coalition partnership made up of the Missouri Motor Carriers Association, the Missouri Insurance Coalition, Missouri Hospital Association, Missouri Biotechnology Association, Missouri Coalition of Children's Agencies, the Metro Medical Society of Greater KC, the Kansas City Neurology Center, Missouri Pharmacy Association, Missouri Retailers Association, Missouri Grocers Association, and the Missouri Chamber of Commerce Industry in support of, the association is in support of this legislation. With that, I'll let these two gentlemen testify.
Thank you very much. Please proceed.
Thank you. I guess I will start by addressing the bill as it relates to Chapter 407. And I'd like to start out by pointing out that the amendments that are being proposed only affect private causes of action under the Missouri Merchandising Practices Act. They don't in any way affect the definition of what constitutes unlawful conduct under Section 407.020. Nor do they affect the ability of the Attorney General to enforce the statute under 407.100. They only affect private causes of action. And
the perspective you get in dealing with national plaintiffs' law firms, from Leaf Cabrazier on the West Coast to the Locks Law Firm on the East Coast, is that Missouri is, as they view it, an open territory. They view the MPA as being ambiguous, and the courts having interpreted it ambiguously enough that they believe that they can use Missouri courts to frame and pursue class actions that they really can't get off the ground anywhere else. A lot of plaintiffs' lawyers have likened it to California prior to the Prop 65 amendments to the California unfair competition laws. We've seen that in a lot of cases for a lot of companies that I represent. Cases where the theory that the plaintiffs advance has been stopped cold in other states. For instance, we represent Coca-Cola in a case called Pennington in Missouri. This was part of a national effort by plaintiffs' counsel. They tried it in a bunch of states. They tried their theory. And the theory is that everyone who drinks Diet Fountain Coke is somehow defrauded under consumer protection statutes because there's saccharin as well as aspartame, which many people know, most people don't care about. It doesn't make a difference to 99% of the people. Illinois shut it down. Kansas shut it down. All the other states shut it down. The only state in which they got any purchase was Missouri, where a nationwide class was certified. We've had similar problems with other litigations. Another one that comes to mind is a Daimler Chrysler Wheels case I represented, in which certification was denied in Kansas, denied in California, Missouri. It was going forward, and we ultimately had to resolve that case. And I won't bore the committee with other examples, but I think the point is there's a lot of ambiguity in what the causal nexus has to be under the NPA and what the actual injury standard is. And what we're seeing are huge overbroad classes framed by plaintiffs' lawyers that include basically everybody who ever bought the product, whether you cared about what was concealed or not, allegedly said, whether it injured you. We also see a lot of classes composed of people who there's nothing wrong with their products, where it's a potential defect case, i.e. my product hasn't broken, but somebody else's has, therefore I want all my money back. And that raises some problematic questions of whether the NPA was intended to cover those kinds of cases.
But it might interest you, and or maybe it will, I'll just ask you. I've received nearly 20 emails today, although it's only been publicly noticed up for 24 hours, as I say, from members of the bar around the state. And every single one of these emails that I've received today opposes this bill. And I'll tell you that just a couple of real quick ones from an attorney here. This one's from Kansas City, where I'm from. Urging you to vote no on 2241. The expert witness standards in medical malpractice cases are already extremely stringent and were made more stringent a couple of years ago. Additional requirements that in order to qualify as an expert witness, the expert must be from Missouri and be published would essentially make the practice of even the most meritorious malpractice claims impossible. Another talks about the consumer protection aspects. Missouri Merchandising Practices Act is a helpful tool in combating those who seek to harm consumers. Changes proposed by House Bill 2241 will weaken the bill, make it easier for those that prey upon unsophisticated consumers to avoid punishment for their wrongs. The other changes tacked on the bill relating to adopting the federal Daubert standard for expert witness are further attack on the Missouri rights of citizens, free access. The last one I was going to, there are about 20 of them, I'm not going to read them all to you. This one's interesting. My background is interesting as it pertains to this proposed bill. I believe it provides an objective perspective. My father was a surgeon. My political background is as a Republican. This is an attorney speaking now. He says, additionally, I practice all forms of litigation, including representing defendants and plaintiffs. The reforms that went into effect in August of 2005 was sufficient. I can honestly say that what is listed in 2241 is excessive in every sense and will actually keep legitimate claims out of court. I ask you to see with this bill for what it is, something completely overboard and detrimental to people. Please vote no. And I could go on through the other 17 here, and I've got no support at all for the bill. So I'm wondering why Shook Hardy and Thompson Colbert are supporting this bill. It seems to have unanimous opposition from the bar.
Sure. Well, let me take a stab at that.
Okay, I thought you might.
People obviously have strong feelings about the NPA. Mm-hmm. Some people view it as an absolutely essential means of advocating consumers' rights. Other people view it as very rife to abuse. I think what this bill tries to do is to maintain the ability of people who've really been injured, who really didn't get what they paid for, to continue to bring suits. I think the point of this bill is to avoid the massively overbroad class, the blunderbuss approach. I don't think anybody in this room disagrees with the fact that people who have legitimately been cheated through consumer transactions need a day in court and they need a mechanism. I don't think, conversely, anybody in this room thinks that people who were never affected or harmed in any respect by the alleged conduct should be part of an overbroad class or be able to get a windfall through conduct that didn't affect them in any respect. And I think the key on the NPA is getting the right balance between making sure people have their day in court and a mechanism to affect that and avoiding an overbroad approach to it.
Great answer.